For the record, this matter is before the court for purpose of reviewing parenting time. This hearing is being conducted via Zoom. The present is plaintiff mother, Lindsay Prater. In addition, defendant father, Aaron Prater, is present, and maternal grandfather, Mark Kipp, is also present. Good morning, everyone.
Good morning.
Good morning, Your Honor.
The parties have conferred with Mr. Walker from the front of the court this morning. Good morning, Mr. Walker. Mr. Walker is proposing that there's a modified parenting time schedule, which I will share with everyone. Mother shall have parenting time every other weekend during the school year, from Friday after school to Sunday at 5 p.m. During the summers, summer break from school, mother shall have parenting time every other weekend, Wednesday at 5 p.m. to Sunday at 5 p.m. In addition, mother shall have 1 week during the summer break, Monday at 5 p.m. to Sunday at 5 p.m. Mother's week-long parenting time shall occur after her first scheduled weekend each month during the summer break. Mr. Walker, is this a recommendation that she has 1 week every month?
Yes, Your Honor. In essence, the first weekend that you would have each month during summer break will be a week long instead of the weekend, and then her next scheduled weekend will be the weekend.
All right, thank you for that clarification. It's further recommended that the party who commences parenting time shall pick up the minor child. Mother shall pick up the minor child at father's home. Father shall not leave the home when mother picks up the child. Father shall pick up the child at Circle K on Monroe Street in Carlton. The party shall celebrate holidays as agreed upon. If there's no agreement, the party shall follow the friend of the court holiday schedule. Further, that prior parenting time orders regarding grandparenting time are vacated. Mark Kipp, maternal grandfather, is no longer a third party of interest in this matter, as mother's parenting time is no longer supervised. That is a recommendation. It seems like a positive recommendation for mother and the minor child. Ms. Lindsay Prater, do you understand the recommendation, and are you asking the court to adopt the recommendation?
Yes, sir, I am.
Dad, Mr. Aaron Prater, you're muted. Do you have any objection to the court adopting this recommendation?
No, Your Honor. No problem.
All right, Mr. Kipp, the same
Yes,
question to
Your
you. Are you asking the court to adopt this recommendation?
Yes, I agree to it, Your Honor.
Okay, so it sounds like obviously Ms. Prater has maintained sobriety. That's all everyone wants. Father as well as the grandparents. Wait,
I do.
thank you. We'll start with you, Mr. Kipp. Mr. Kipp, do you believe this agreement is in the best interest of the minor child, Charlotte? Your
Yes, I do.
All right. Do you have any questions for Mr. Walker or the court?
I do not.
All right. Mr. Aaron Prater, do you believe this agreement, this recommendation and agreement is in the best interest of your daughter, Charlotte?
Yes, Your Honor.
Do you have any questions for the court or for Mr. Walker?
No, Your Honor.
All right. Ms. Lindsay Prater, do you believe this recommendation is in the best interest of your daughter?
I do, sir.
And you are committed to sobriety and being the best mom you can in the world, right?
Absolutely, sir.
Wonderful. That's all everyone wants for Charlotte. So the courts, obviously, Mr. Prater, you've had support from not only your from Mr. Prater, but also your father. So you should be fortunate and recognize and be grateful for that. Simply wanted to get to this point, helping you along. So it's nice to see that happy smile. In any event, the court finds this recommendation being best interest of minor child, the court will currently adopt the same. Right, each of you mailed a copy of this. That will conclude this hearing. Good luck to all three of you, and we wish the best for Charlotte.
Thank you so much, sir.
You're welcome. You can zoom out. Have a good rest of the day.
Mr. Castro,
Thank you, Your Honor.
please remove your
Welcome.
hand. We're about to begin. Thank you. Sabrina Castro versus Jesse Castro.
For the record, this matter is before the court on the plaintiff mother's motion to modify custody. This hearing is being conducted via Zoom. It appears that both parties are present. Plaintiff mother Sabrina Castro and defendant father Jesse Castro. Good morning.
Good morning.
Good morning.
The two of you have conferred with Mr. Walker from the front of the court this morning, who has provided the court the following recommendation. That parenting time shall be as follows. The parties shall have parenting time week on, week off with exchanges on Sundays at noon. Further, the parties shall share holidays as agreed upon. Of course, we'll let you know, even though this recommendation does not state that, if you cannot agree upon holidays, the fallback is the Monroe County Front of the Court holiday schedule. You can get that online. Recommendation. Ms. Castro, do you understand the recommendation?
Yes.
And of course, the two of you will continue to share joint legal custody, which means you share equally any major decision concerning the welfare of your two children.
Yes.
Ms. Castro, do you have any objection to the court adopting this recommendation?
No, sir.
All right, Mr. Castro, same question to you. Do you understand the recommendation, and do you have any objection to the court adopting the recommendation?
No, I do not. And absolutely,
Right.
I do understand.
I swear.
Thank you. Ms. Castro, please state your name for the record.
Sabrina Castro.
Ms.
Can you hear
Castro, do
me?
believe this? Yes.
Oh,
Do you believe
sorry.
believe this recommendation is in the best interest of your two children?
Yes, sir.
Okay. Thank you. Do you have any questions?
No, sir.
Right, Mr. Castro, same question to you. Do you believe this a recommendation in the best interest of your two children?
Yes, sir, I do.
All right. The court finds agreement between the best interest of the two minor children. The court will call the adopt agreement. And also the court's going to conduct a pretrial conference at this point in time and schedule this matter for mediation. Mr. Walker, I don't know if you have, I don't have my mediation schedule in front of me. The two of you have been separated since March of 2021. Is that correct?
That is correct, sir.
Is there any chance of reconciliation?
No, sir.
No.
All right, so let's get this matter moving. Typically, what the court would do is schedule this matter for mediation with front of the court, like Mr. Walker is a certified mediator or someone else from his office to work through any issues. So I'd like to identify what are the issues. Obviously, you've agreed upon custody parenting time. Is there real estate to be divided?
No, sir.
Personal property?
No, sir.
You've been separated for almost, 3 years?
Yes, sir.
So what has prevented you from getting divorced?
Waiting for the court date.
Okay, well, you got a court date today.
Can we get divorced today?
Well, you need to, Ms. Castro, you went online and you printed out a form of complaint, correct?
Yes, sir.
So you need to go online and get what's called a judgment of divorce with children.
I have that, sir. I just have to get it turned in.
Okay, so you need to complete that. For example, it says, joint legal custody, week on, week off parenting time, exchanges on Sundays at noon. The other thing you need to agree upon is child support. Mr. Walker can provide you with a recommendation because you need to also attach to your judgment of divorce what's called the Uniform Child Support Order, in which you address child support. Unless you're going to agree that child support be reserved, then each will support the child while in their respective possession. But that can be difficult because obviously you have issues like school clothing, if they're in sports, athletic items. So the one thing you need to probably do is we need to address child support judgment divorce. But the other thing is there are no joint debts, correct? So if you look at the judgment divorce, it's basically fill it in the blocks. And no real estate, no joint debts, retirement. You've been married 3 years, so each of you will keep your own retirement benefits, free and clear of any claimant part of the other. Each will keep their own automobiles, paying debts in their own names. Spousal support is not appropriate. That's alimony because this is a short-term marriage. So there's a block that says spousal support is not awarded. It's forever barred. So you can pretty much fill out that judgment. The court could take some brief testimony this morning, and it means you don't have to come back to court. It's simply you need to both fill out the judgment. Both of you need to sign it and date it on the second page. So two of you should get together, and obviously it's one for the year on terms. So what about child support? Do you want to talk with Mr. Walker, get a recommendation regarding child support? He can, based upon your 1099s or W-2s from last year, he can probably give you a verbal recommendation. Of course, child support is always up to modification. You can always change it. You can go up or down as the needs of the children increase, as your respective incomes increase or decrease.
Absolutely. And so I don't know about Mr. Castro. I, however, am good with foregoing it at least definitely for now, neither one of us have been giving support to the other thus far, and we've been doing good as far as I'm concerned. I don't know Mr. Castro's exact situation, but I'm good with foreloading that now.
Okay, so in judgment of divorce, there's a paragraph we're going to trust, but I just put in there where the word reserved, which means that either side can petition the court at a later point in time. You can't order that they're not being child supported, but you can put the word reserved in there, and that will address that issue.
Okay.
The other issue that needs to be addressed is, Ms. Castro, do you still receive public assistance?
I do.
Okay, Mr. Castro, do you receive public assistance?
I do.
Mr. Castro, do you receive public assistance?
Yes, I do.
Well, okay. The reason I'm asking is because there's a $255 filing fee. And that should not, the taxpayer shouldn't have to pay this. You're both young, able-bodied. I don't see any disability. So that's got to be addressed in your judgment. I'm going to make a note of that. And I don't know how it's paid to the Monroe County clerk. It's got to be paid in one lump sum. They won't accept installment payments. But the court's going to, when the court receives a judgment, the court's going to add some language in there. So I want to discuss with you your agreement relative to who's going to pay that $255, unless you both agree to share that equally.
I'm okay with that.
I'm good with that as well.
You don't know who's got the greater income.
That I'm not sure. I work part-time at Taco Bell.
Okay. So that's means each you pay $127.50. So you make a note. There's a filing fee of $255 paid to Monroe County clerk. Will not take a half payment from Ms. Castro and half payment from Mr. So who's going to pay it? Mr. Castro, will you pay that?
Yes, I will. Yes, sir.
Okay. So you can put in the judgment if you miss it, of course, you can put that in there that Mr. Castro shall pay the $255 filing fee to Monroe County clerk, and Ms. Castro will reimburse him 1/2. So, Mr. Castro, we need to set a date. For example, can you pay that by how much time do you need to pay that? Do you need to the end of May to pay that? The end of April? I mean, end of April.
At the end of May, if that'd be okay, have it due the end of May. I could have it paid by then.
Okay, so we put in the judgment that you should pay $255 filing fee to Monroe County clerk on before May 31st, 2024. And Mr. Castro, if you need additional time, you call the court and I will give you an additional time. Just don't blow it off. You blow it off, that's when bench warrants issue.
Oh yeah, absolutely, sir. I will be taken care of.
All right, so the court would put in the judgment. There's usually toward the bottom before your signature, before the signature for the judge, there's a spot there that says other provisions. You can write in the language, and the language should say defendant Jesse shall pay $255 filing fee to Monroe County clerk on before May 31st, 2024. Plaintiff Sabrina will reimburse him for 1/2.
Okay.
All right, so the court's going to take some brief testimony this morning. There's a breakdown. It's a required testimony that you don't need to come back to court. It's just a matter of submitting that judgment. When you submit that judgment, then you'll be divorced. And Ms. Castro, there's another provision if you want your former name restored. Are you going to keep the name Castro for the benefit of the children?
I was thinking about it. Mr. Walker did let me know that I can check it and then decide later, so I think I will do that.
Okay, so you fill in the blank about your former name restored, put that in there, and it will not occur until you take that judgment to the Secretary of State and Social Security. So in other words, if you decide not to change it, then you just don't you don't provide the Secretary of State and Social Security with a copy of that judgment of divorce. But at least the mechanism is in the judgment to do that if you choose to do so in the future, okay?
Absolutely.
Well, it's wonderful. The two of you can obviously still be friends. For the benefit of your children will thrive when you're on the same page. And there will be challenges in the future without question as they grow up, but you need to be on the same page for their benefit. So wonderful. So in any event, can you both please raise your right hand to be sworn? Again, I'm sorry, you've already been sworn. You both confirmed that this recommendation regarding parenting time is the best interest of children. So Ms. Castro, just for the record, please state your name and current mailing address.
Sabrina Castro.
Thank you. Ms. Castro, is it true that you filed a complaint for divorce with this court on about February 27th, 2024?
Yes.
Is it further true that on the date you filed that complaint that you'd reside in the state of Michigan at least 6 months and County Monroe at least 10 days?
Yes.
Was it further true that you married to Jesse Castro on July 25, 2018? You separated in March of 2021?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the obvious matrimony had been destroyed? There's no reasonable chance of reconciliation?
Yes.
Is it true there were 2 children born of the marriage who are still minors? It looks like Ms. Castro froze up.
Yep, I did. I'm sorry. I'm back.
Ms. Castro, is it true there are 2 children born of the marriage who are still minors?
Yes.
Are you currently pregnant?
No.
Do you have any questions for the court?
No. The only thing is, so after this, I will get the judgment for divorce, get together with Mr. Castro, fill it out and turn it in by May 31st with that filing fee, right?
Well, no, you can turn it in anytime. You can turn in,
Okay.
in the next couple weeks. You can bring it up to Judge Brock's court, or you can put, there's a Dropbox outside the court if you want to drop it off on Saturday or Sunday. Just put an envelope with Judge Brock's name on it. Or if you're
Okay.
bringing it down to the courthouse, if you want to shorten things, you can just drop it off at Judge Brock's office. The court will sign it, then each of you will be mailed a copy. So you don't need to wait till May 31st to do that, but there needs to be an added, you need to write in the judgment about the payment of the fine fee by May 31st. So
Okay.
that can be, the judgment can be entered before then. All right, Mr. Castro, can you please state your name, current mailing address for the record?
Jesse Castro.
Thank you. Mr. Castro, did you hear the testimony this morning of your wife, Sabrina?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Do you have any questions for the court?
No, I do not, sir.
All right. Again, it's wonderful the two of you are on the same page. Based upon the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the opposite matrimony has been destroyed and there appears to be no reasonable likelihood that marriage can be preserved. Accordingly, upon receipt of the written consent judgment of divorce approved by both parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce in bonds of matrimony. Well, good luck to both of you. No need to come back to court. Just print out that judgment of divorce. If you cannot find it online, you can always come down to Judge Brock's courtroom and we can print one out for you, Ms. Castro.
Okay.
All right, good luck to both of you, and we'll wait to receive that judgment, and the court will sign it. No need to come back to court. Well, good luck to both of you.
Thank you,
Good
sir.
luck. Thank you so much.
Welcome. You can zoom out. Have a good rest of the day.
You as well.
You as well.
Bye.
For the record, this matter is before the court on the plaintiff's motion for child support. This hearing is being conducted via Zoom. Present is Attorney Eric Chappell, representing the plaintiff petitioner Karen Newsome. Ms. Newsome appears to be present. Mr. Chappell, in addition, Attorney Matthew Viddo is present, representing the defendant Brent Newsome. Mr. Newsome appears to be present with Mr. Viddo. Good morning, everyone.
Morning, Your Honor.
There's also, and I don't know if this was discussed this morning, Mr. Chappell, Mr. Viddo did file a motion for to show cause, which is scheduled for hearing on, it was filed yesterday. The court entered an order yesterday scheduling the matter for hearing May 29th.
I think we have a global resolution, Your Honor.
Okay, wonderful. I was just hoping that could be discussed. If not, the parties could mediate the issue. In any event, the parties have conferred with Ms. Patrick from front of the court. Ms. Patrick has provided the court with a fine recommendation. The court recognizes a 16-year-old child. That with respect to child support, commencing March 1st, 2024, a defendant, father shall pay child support in the amount of $800 per month. Uninsured medical expenses shall be shared as follows. Plaintiff mother paying 39%, defendant father paying 62%. This is based upon defendant father having 75 overnights per year. It's further recommended that the defendant's motion for show cause be withdrawn. And of course, with that, the hearing of May 29th at 1:30 would be vacated. With respect to parenting time, defendant father shall have 1 weekend a month by agreement or such other times as parties can agree. A father shall have summer parenting time of 2 non-consecutive weeks during June and July with 30 days advance written notice to plaintiff mother. Party shall continue to use their friendly court holiday schedule, and party shall share transportation apparently as they have in the past. That's the recommendation. Mr. Chappell, is this recommendation agreeable with your client this morning?
It is, Your Honor. Just as you recited it, I would just want to add that the summer parenting time is also by agreement. The intent, and with me saying that, Your Honor, is to just make sure that it works with the daughter's schedule and everyone. And obviously the time will occur, but they will do that by agreement as they do the 1 weekend a month.
And
But
I did omit.
otherwise, everything is as we agreed.
Thank you, Mr. Chaplin. In fact, Mr. Patrick does have the word by agreement in there. I just didn't say the word agreement, but it does say 2 non-consecutive weeks during June, July with 30 days notice by agreement to the plaintiff mother. So that is noted as part of this written recommendation, recommended order. You're welcome. Mr. Vido, does your client have an objection to this recommendation?
Well, there's one correction I think needs to be made because my recollection was it was 1 weekend per month and any additional time by agreement, not or should not be 1 week in a month or any other time agreeable by the parties. It should be and any additional time agreeable by the parties. So it's a minimum of 1 week in a month and any additional time agreeable by the parties.
Correct.
And Ms. Pat, perhaps you could modify this and indicate the defense file shall have 1 week in a month by agreement and any other times parties can agree. We'll just change, we'll delete the word or for and. Is that what you're suggesting, Mr. Vido?
Yeah, I don't have the written phrase in front of me, but if it's phrasing it the way that you have, I think that's accurate.
Yes, it's the way it's written is defendant filer shall have 1 weekend a month by agreement or other times as agreed. And you want the or to be replaced by the word and.
Correct. Thank you.
Right.
I think everything else was acceptable and accurate.
Thank you. Any objection, Mr. Chappell?
None, Your Honor. That was the intent.
Okay. All right. So Ms. Patrick, we just eliminate the word or and replace it with the word and.
Yes, Your Honor.
Clarify that. All right, Mr. Newsome, looks like Ms. Newsome is now, her last name is Godin. Can you both raise your right hand? Right, Mr. Newsome? Mr. Newsome, you need to speak up. We can't hear you from back there.
I said yes.
Thank you. Thank you. All right, Mr. Chappell, we want to just briefly voir dire your client, please.
I will. Could you state your full name for the record, please?
Karen Elizabeth Godin.
All right. And you had the opportunity to participate in the front of the court meeting that we had this morning. There were negotiations back and forth, correct?
Yes.
Okay. Is it your decision to enter into this agreement today?
Yes.
You understand that if you would have the ability to have a hearing where the court would determine incomes and you might receive a higher number in child support. But do you believe that this is in the best interest of your daughter?
I do.
Okay, and you're comfortable, you feel this is a fair resolution of all the issues that have been raised by yourself and Mr. Newsome?
I do.
Okay. All your questions have been answered?
Yes.
Happy with my representation?
Yes.
Okay, thank you.
Thank you, Mr. Chappell. Mr. Vido, do you have any questions, first of all, for the plaintiff mother?
No, I don't. Thank you.
Any questions for Mr. Newsome, please?
Yes, Mr. Newsome, remember to speak up, but you've heard the agreement that's in place on the record?
Yes.
You're asking the court to adopt this agreement?
Yes.
Okay, and you understand that had we gone to a contested hearing in this matter or a trial, we could have reached a much different result.
Yes.
It could have been better or worse.
Yes, correct.
Or even the same.
Yes.
But you want the court to adopt this one.
Yes, that's correct.
Do you believe that this agreement is in the best interests of your minor daughter?
Yes.
Okay, and do you believe that the outcome is fair, all things considered?
Yes.
Okay. And in the capacity of the resolution session that we were in, you were able to go back and forth and negotiate this outcome.
Yes, that's correct.
Okay. Are you satisfied with my representation?
Yes.
Okay. Thank you. No further questions.
Thank you, Mr. Vido. Mr. Chappell, do you have any questions of Mr. Newsome?
I do not. Thank you, Your Honor.
Okay. Lastly, and of course, the court's aware by Mr. Vido's motion that plaintiff mother and the minor child live about 3 hours away from dad. They're both on the same page relative to transportation, correct? I don't know if they're meeting halfway or.
Yeah.
Yep. Yes, Your Honor, they've had a system in place that we are going to keep in place.
Wonderful.
Yep.
All right. So with that, the court finds agreement between the best interest of minor child. The court will adopt the agreement. Court would like to thank Ms. Patrick for her assistance, as well as, of course, Mr. Attorneys Vido and Chappell for helping facilitate amicable resolution of this matter. The minor child's going to be an adult before we know it. All right. That will conclude this hearing. Thank you all. You can zoom out. Have a good rest of the day.
Thank you, Your Honor. Have a good day.
Thank you.
And the hearing of May 29th is vacated, Mr. Vido.
Yes.
Thank you, Your Honor.
Thank you.
Court is recalling case 2, Jamie Mabel versus William Phillips.
Thank you, Mr. Walker. This matter is before the court for the purpose of reviewing post-judgment status of the sale of a trailer, as well as payments, financial obligations due from the defendant to the plaintiff. Is Jamie Mayville present on audio?
Yes, I am.
Good morning, Ms. Mayville. Mr. Phillips, apparently was taken to the hospital this morning or last night. Apparently he's in the hospital. I hope he's okay, but in any event, some family members or friends contacted the court advising that he may not be able to appear this morning because he's in the hospital. And Mr. Phillips has, and I don't know if you've been served with it, he's filed a motion for order to show cause. He's alleging that that you damaged and totaled the car, and also that you canceled credit card debts. Any event, I don't quite understand his allegations, but his motion directed to you is scheduled for on June 18th at 1:30. Since he's unable to appear today, we're going to put this review over to the same date and time, June 18th at 1:30. It'll be a Zoom hearing, so note that in your calendar. You'll be mailed an order reflect that Mr. Phillips failed to appear. Thank you, Mr. Walker. That at least keeps the court file clear that it was set for hearing today. Mr. Phillips failed to appear. He's hospitalized. So the mayor is adjourned June 18th at 1:30. But while we have you on, Miss Mayville, has he been paying the $500 a week?
No, he is not.
He was to pay $500 a week getting March 15th, so he did not receive any payment this month. Is that correct? Or April?
Yeah, I received a $300 payment, and that was it on March 15th.
Okay, yes, of course, he was to pay $500, but you received $300 on March 15th, correct?
Yes, that's it.
All right, I'll make note of that. And do you know if he's been able to sell the trailer?
No. Matter of fact, he's about ready to get kicked out of the campground where he's at.
Okay.
It's been booted. He owes them $2,700.
Okay, all right.
He owes a lot of people.
Okay, of course, you can always hire an attorney. Maybe the attorney can, confiscate the trailer or something. Especially, you don't want that trailer being foreclosed upon.
I don't want that camper. He already took everything out of it.
All right. Okay.
He's ruined it.
All right, so we'll keep after him to get the balance. Miss Mayville, again, this matter is adjourned to June 18th, 1:30 p.m. For the record, this matter is before the court for the purpose of reviewing some post-judgment obligations of the parties, specifically payments from the defendant to the plaintiff and the status of the sale of a trailer. Also before the court is the defendant, William Phillips, a motion for to show cause. Is Jamie Mayville present on audio? Miss Mayville, can you hear the court?
Yes, sir.
All right, I didn't hear you guys speak up. And sir, you're William Phillips, is that correct?
That's correct.
All right, good afternoon. Both of you, the two of you have conferred this afternoon with Ms. Prater from the front of the court. She has indicated that the court recommended the court enter the following order, knowing that the payment has been paid in full regarding the trailer. The show cause regarding the firearm, the gun is dismissed because there's no award of specific property in the judgment of divorce, no reference to a gun. And finally,
Your Honor, how can a person?
Hold on just a minute. Ms. Mayville, do you understand the recommendation?
Yes, I do.
Okay. Do you have any objection to the court adopting this recommendation?
No, I don't.
Okay, Ms. Mayville, you acknowledge you received in full what you were provided for in the judgment of divorce.
Yes, I have. I didn't
In
take
other
the
words-
interest. I just wanted it paid off and buy,
Okay, so you received the remaining balance of $3,500, correct?
Yes, that's it.
All right. Now, Mr. Phillips, of course, has alleged a couple of issues. One, just one moment, let me refer to his motion for show cause. He's alleging that you stole a rifle and a holster, and you poured water on his computer and damaged it. What's your response to
No.
those allegations?
No, I did not do that.
Okay, did you take the gun?
No, I did not take the gun.
What about the holster?
No, I did not take the holster, and I did not damage his computer. So I know I read the motion, and I'm like, where is this coming from? And his witness that he has, that is not no witness. So
Okay.
I don't know where
Okay.
all this came
All right,
from.
so you denied, do you have any idea where the gun and the holster are?
Yeah. You can come to my house and come through it. I don't have it.
Okay, Miss Mayville, the question is, do you know where they're at?
No, I do not know.
Okay, also, Mr. Mayville has alleged that certain credit cards, I don't quite understand the allegation, but certain credit cards were canceled. As you reported, the charges were not yours, and they erased the debt as to you.
No,
What about,
that's not
what
true
about
either.
that?
That's not true either.
Okay. Did you call the credit card companies?
Yes, I did. Yeah, they're aware of it.
Okay, the judgment of divorce does not make any reference to Mr. Phillips being awarded a gun. Basically, the judgment of divorce says that each party is awarded the personal property currently in your possession.
He sold his guns out in Jackson to get out of a campground because he was running from a bill.
Your Honor,
I don't
she
know
is
what this.
lying to you. One lie after another. I have done everything this court has asked me to do. I didn't mention.
Oh, you did.
Hey, hold on.
We'll
This is not the opportunity for you
Out
to
there.
argue against each other. Just respond to the court, please. Miss Mayville said she doesn't have those items, doesn't know where they're at. Mr. Phillips, the judgment of divorce says that each party is awarded the personal property currently in their possession. If in fact she possesses a gun you want, you need to specify in the judgment. So whatever you had at the time, you keep. Whatever she had, she keeps, and she denies having the firearm or the holster.
Correct.
So the court cannot do anything about that. But what about these debts? The judgment also says that.
Oh, that's already taken care of.
Hold on, Miss
Become a
Mayville.
state-
Please don't interrupt, Miss Mayville. Miss Mayville.
Okay.
Not interrupt, please. Judgment also says that the plaintiff, which is Jamie, shall pay the balance of the Kohl's, Discover, and Capital One credit cards. And have those? Was your name on those cards, Mr. Phillips?
Yes. No. My names were never on any credit cards.
Okay, so hold on. Let me stop right there. Why is it an issue then? If your names are not on the credit card debts, who cares if Miss Phillips got the debt erased? Because your name was not on there, so it does not affect you adversely.
The reason I paid the debt is because I got no way to prove that I can't get into I'm not on her credit cards. I cannot find out the information of what she did with them. So there's no proof. So I gave her the money. I just want my guns back.
Okay. Well, you should provide for that in the judgment, Mr. Phillips. There's nothing in the judgment that says you're awarded a rifle. So the court assumed that you had everything of those things in your possession. Now, if in fact she stole it, the court suggests make a police report or make an insurance claim. If it's been stolen, make an insurance claim. Then of course insurance companies can want police reports. Make a police report. Yeah, you can tell them who you think took it, and they will and at least get a police report. And then even if they can't locate it for you, they don't charge Miss Mayville. At least you can use that as a basis to make an insurance claim.
Your Honor, at this point, Monroe County Sheriff is involved with this, that we were waiting to see whether or not she was going to voluntarily give the guns back. If not, we're going to pursue for gun theft.
Okay, that's what you should do. That's your really only course of action at this time, Mr. Phillips, is to make a police report, see if they'll prosecute Miss Mayville. If not, then at least you got a police report you can take to the insurance company. But the judgment of divorce does not reference a firearm, so since she denies she has it, there's nothing this court can do.
All right. Well, I'm gonna do it the other way then. That's I was
Of course,
hoping.
if you have any proof that she damaged your computer, you can sue her civilly as well. I don't know what witnesses you have that she damaged that. And again, there's nothing in judgment that says you're awarded a computer. So we're talking about things that were not even addressed in the judgment.
Well, I still have the computer. I can prove it's water damage that was poured into it.
Okay.
Well, he's had that in his possession for 2.5 years. I don't know what he did with it. He's moved into different women's houses. I don't know.
All right. It appears to the court, hold on, Ms. Mayville, it appears to the court that all outstanding issues have been addressed. This court, as a divorce court, cannot do anything more than what to enforce the terms of this judgment. And Ms. Mayville, you've indicated that you've been paid in full. Mr. Phillips, the issues that you've raised about the credit card debts are not in your name, so it shouldn't be any concern to yours. And I understand you paid her $3,500, but again, that's what two of you agreed upon. The court just simply entered the consent judgment. And so everyone has been paid. And now, did Ms. Phillips, did you sign off title to the camper?
Yeah. Yes, I did.
All right, is that correct, Mr. Phillips? You signed off and given you the title?
I have done everything everybody wanted me to do. All I wanted was my gun back. I mean, my God.
Mr. Phillips, the question is, did she sign off on the title to the camper?
Yeah, she did.
Okay, all right. It appears that everything has been addressed. There's no need for another review. There's nothing the court can do further to enforce terms of its judgment. So the court will adopt a recommendation of Mr. Pratt that the trailer, noting the trailer has been paid in full, and the show cause regarding the gun is dismissed because there's no reference to that gun in the judgment of divorce. All right, that will conclude this matter. I wish I could grant more relief, but I'm bound by the terms of the judgment of divorce. Mr. Phillips, once again, make a police report and turn that into insurance if they're not prosecuting Ms. Mayville. All right, that will conclude this hearing. You can both zoom out. Have a good rest of the day.
Thank you.
You're welcome.
I'm not gonna get my gun. Like, I'm gonna kill that bitch.
For the record, this matter is before the court for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. President is Attorney Steve Jednick, representing the plaintiff father, Derek Verley, and Mr. Verley appears to be present with Mr. Jednick. In addition, Attorney Michael Keeney is present, representing defendant mother Sheila Hall, and Ms. Hall appears to be present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Court's aware we have a minor child, about 8 months. The parties have conferred with Ms. Patrick, who will soon be providing the court with a recommendation. So I heard some technical problems this morning. Ms. Patrick, perhaps you can you verbally state on the
Yes,
record
Your
what
Honor.
your recommendation is? I have not seen anything yet. I'm not sure what the problem is.
Your Honor, the following is the recommendation from the friend of the court. We have one child who is 8 months old. Plaintiff
Correct. Court's aware of all that. The court's aware of the February 8th, the order. They had parenting time every Friday, 3 to Sunday at 5, and every Monday and Wednesday, 3 to 8.
So the recommendation today, Your Honor, is going to be the plaintiff father will have every other weekend from Friday at 2:30 till Sunday at 8 p.m., commencing May 3rd of 2024. Plaintiff father will have every Tuesday, Wednesday, and Thursday from 2:30 p.m. until 8 p.m., commencing 4/24 of 2024. Plaintiff father will ensure that when he is transporting the breast milk for the minor child, that the milk remains frozen. And lastly, the defendant will provide a copy of the minor child's medical insurance card to the plaintiff father. That is the extent of the recommendation today, Your Honor.
Thank you, Ms. Patrick. Mr. Jednick, is this recommendation agreed with your client this morning?
Yes, it is. We accept.
All right, so thank you. Mr. Keeney, is this recommendation agreed with your client this morning?
It is, Your Honor. Thank you.
Okay, do you both wish to voir dire your respective clients? You want them sworn this morning?
I personally don't believe that's necessary. However, I will follow Mr. Jednick's suit.
I don't think it's necessary. Thank you.
Well, the court would note, thank you, that both parties did participate in the conversation and discussions with Ms. Patrick this morning. No need for another review then, correct?
Correct. I'm not asking for one. The parties could file a motion if there's a problem.
Very well, wonderful. It's wonderful the parties can work together, and obviously, Mr. Verley, Ms. Hall, communication is the key. You got to be flexible with each other. If there's an issue regarding your respective schedules or that of your child, contact the other party. We'll work with each other. Thank you, Ms. Patrick, for your assistance this morning.
You're welcome, Your Honor.
The court will, upon receipt of the recommendation, will sign and okay, the court will adopt the recommendation. Copy mailed out. That will conclude this hearing. Everyone can zoom out for the rest of the day. Thank you, Mr. Two of you have conferred with Mr. Walker from the front of the court, who has provided the court with a fine recommendation. If the court adopts the recommendation, it will become an order of the court. The recommendation is that defendant Crystal is no longer required to use Smart Start as required for her parenting time. That was previously agreed upon the parties and when incorporated in the judgment of divorce back in May of 2023. It's further recommended that spousal support paid by plaintiff Stephen to defendant Crystal be modified or reduced to $1,088 per month, effective May 1st, 2024. It's a reduction from $1,945 to $1,088 per month, effective May 1, 2024. Appointments, of course, would continue to be made through the front of the court. Of course, that will continue, I believe, for a period of 6 years. The balance of the 6 years from and after the judgment of divorce in May 2023, but that's a recommendation. Mr. Marquez, is this recommendation agreeable with you this afternoon? I'm sorry?
Yes, it is.
Okay, Ms. Marquez, do you understand the recommendation?
Yes.
I do.
Crystal, do you understand the recommendation?
I do.
Are you agreeable with the recommendation?
I am, as long as it's modifiable.
Yes, it'll be, so in other words, if circumstances change, those birds out there. So if circumstances change, if I'd rather get into the details, if Mr. Marquez has a reduction in income, or he's got some other significant issues, if in fact his income goes back up, yes, you can petition the court to modify it.
Okay. Thank you, Your Honor.
So it's until further order of the court. You understand that,
Okay.
Mr. Marquez?
Yes. Yes, I do.
Do either of you have any questions?
I do not.
Okay, well, the court applauds you for being able to reach your own agreement. If nothing further, the court will adopt the recommendation. You both mailed a copy, and that will conclude this hearing. You can both zoom out. Have a good rest of the day.
You too. Thank you.
You're welcome. Matters before the court for purpose of reviewing parenting time primarily and any other issues. This hearing is being conducted via Zoom. President Attorney Alex Goldman representing the plaintiff mother, Hazel Merritt. Mr. Goldman is present. Good afternoon, Mr. Goldman.
Good afternoon.
Hazel Merritt, are you present in audio?
Yes, I am.
Good afternoon. Is Martin O'Neill present in audio?
Yes.
All right. Good afternoon, Mr. O'Neill.
Good afternoon.
Parties have conferred with Ms. Patrick this afternoon for the front of the court, who has provided the court's following recommendation. Presumably, parenting time will continue as previously ordered. It's further recommended that in order to enter that the minor child shall not be taken to any correctional facility, to any prison or jail without father's permission. I suppose it should be both ways. Dad should not be taking the child to a correctional facility without mom's permission. So the child should not be taken to any correctional facility without the permission of the other parent. Consent. Further, that the $35 expense for a missed dentist appointment will be added to the front of the court account, and the defendant father will pay that to the front of the court. The court recalls back on March 5th, the court ordered that Mr. O'Neill reimbursed Ms. Harrod $35 for that missed dental appointment, and apparently Mr. O'Neill cannot do that, so it's to be added to the child support. And further, that the minor child shall have access to her phone and charger. That's the recommendation. Mr. Goldman, is this the recommendation agreed with your client this afternoon?
Yes, Your Honor.
Right. Mr. O'Neill, do you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting this recommendation?
No.
Okay. You don't have $35. You can pay this expense to Ms. Merritt?
Well, I had the $35 and I got Elijah hair done. So I paid the lady the $35 like she told me to. So now she need another $35. I have no problem doing it. I just want to take care of my child and stop coming to court. That's all I'm gonna do. I don't want to argue or none of that.
Mr. O'Neill, O'Neill, hold on. But 6 weeks ago, you ordered to pay $35. Why had you pay that? So it's not $350, it's $35.
Because I only have one income. She have a bunch. She got all that shit over there.
Okay.
Like, come on, man.
The answer is the court's question. I don't want to open a can of worms. I just was wondering
Yeah,
if you paid $35. So in other words, that $35 that you owe for the dental appointment will be added to your front of the court obligation. Understood?
Yes, sir.
Understand that, Mr. Martin? Mr. O'Neill, I'm sorry.
Yes, sir, I do. What I don't understand is, can I say something?
Well, do you have a question?
Yes, I do.
Okay, what's your question?
My question is, why is it that Miss Mary get all the benefits for Elijah, but she calls me for money and gas money and tells me that she's going out for child support because she can't afford to take Elijah back and forth to school and all this. Like, how is we going to like break this up so when she's here, she can have something coming in here instead of her just getting all the
Mr. O'Neill, you have no obligation to give her directly money. You have no obligation to pay for your daughter's haircut. If you choose to do it, it's the right thing to do as a parent. If you say, I can't afford it, I'm not going to do it, you have no court order that says you got to pay for her hair appointments.
No, that's what I did with the money. I took the $35 and I gave it to the lady.
That's good. But Mr. O'Neill, you're not ordered to do that.
Okay.
You're not ordered to do that. So that was your generosity as a parent. So it's a good thing. Anything further, Mr. Goldman?
No, Your Honor.
Do you need
so you just gonna ignore what I just asked you?
You need to voir dire Ms. Merritt, Mr. Goldman, or is that not necessary?
I don't believe it's necessary, Your Honor.
All right, Mr. O'Neill, did I answer your question?
No, you didn't.
Your Honor.
Okay, Ms. Patrick, perhaps you can answer the question.
I can help answer Mr. O'Neill's question. Mr. O'Neill, if your question is about the DHHS benefits that she's receiving, then you would
And
need,
Social Security.
okay, so you would need to go to the Department of Human Services on Telegraph Road and discuss that benefit with them. This court has nothing to do with those benefits. We don't provide them and we don't see them. Also with Social Security, you have to go talk to the Social Security agency. This court doesn't have anything to do with either one of those benefits.
Okay.
Okay?
Yep.
All right, thank you, Ms. Patrick, for answering
welcome.
that question. All right, that will conclude this matter. I'm pleased to hear, Ms. Merritt, Mr. Neal, that you're working out parenting time.
Yes, sir.
And I understand it's an expense for Ms. Merritt to transport the child to Arborwood Schools, but she was the one that chose to move out to the west part of the county. So that will continue. All right, now everyone can zoom out. Have a good rest of the day, everyone. A copy of this will be mailed to Mr. Goldman as well as to Mr. O'Neill. Good job. Okay, you can zoom out. Have a good rest of the day.
Thank you.
Thank you, Your Honor.
You're welcome. For the record, this matter is before the court on the plaintiff wife's motion for contribution toward medical and the plaintiff wife, Veronica, also attorney Pascal. Is it, how do you pronounce your last name? Ukpabi?
Ukpabi, Your Honor.
Bobby. All right. Good afternoon, Mr. Ukpabi, representing the defendant husband. The parties have conferred with Mr. Walker from the front of the court. Mr. Walker has provided a fine recommendation that effective March 1st, 2024, the defendant husband shall pay $1,335 to plaintiff for his half of his marital bills until further order of the court. That is the recommendation. Ms. Skorsky, is this recommendation agree with your client this afternoon?
It is, Your Honor.
Mr. Ukpabi, is this recommendation agree with your client this afternoon?
Your Honor, my client respectfully objects to this recommendation because it was done without proper information gotten from my client. All we saw was we appeared and all of a sudden, a certain amount of money was mentioned. And certain things that went through the hearing with the respectable referee, and we object to it. The starting statements that were made, we object to it. And the referee was supposed to caution. Why would the plaintiff talk about saying it's the Nigerian thing? Your Honor, we object to that. And we expect her to apologize before this court. Otherwise, we take it to a different level. I don't know what being a Nigerian thing means. I am Nigerian. My client is a Nigerian. I don't know what that means. By birth. But I happen to be an American citizen, but I was born in Nigeria.
Okay. Is your husband willing to contribute anything toward these expenses? Is it just the amount that's in dispute?
You know, my client has been contributing, paying all the bills up until he was pushed out of the house by the plaintiff.
Okay,
and
so he does not feel responsible to pay any to contribute any expense at this point. That's your client's position?
My client's position is that, in fact, is the plaintiff that's supposed to pay him back for all the things he has been paying, all the money he's been paying. He's been taking care of the family until he was pushed out of the house. Why would the referee recommend him to pay this amount of money for what? He was pushed out of the house in the code.
I understand. I understand. I've read your response to pleadings. I understand your argument that he was pushed out of the house. So because of that, he's not does not feel obligated to contribute anything toward these expenses. Is that correct?
You know, he had to rent a new place. He rented a new place with his kids, and he applied for his name to remove from the lease.
All right. Is there any chance of reconciliation of this marriage?
Well, you know, as you know, there's always a chance to reconcile matters, you know, between the husband and wife or between any two parties. There's always a chance, but it has to follow the due process. That is my own understanding, and that's my.
I understand. Is there any chance for reconciliation in your client's opinion?
I mean, you know, I talking about reconciliation in terms of the monetary aspect or marriage.
It doesn't want it.
I don't know. It's a reconciliation. I don't know. I don't understand what. you mean by reconciliation?
Oh, they're separated. They can't agree upon what day it is today. Is there any chance that they may remain married?
I don't think so, Your Honor.
All right, Ms. Gorski, does your client believe there's any chance for reconciliation?
No, as she indicated in her complaint, under the current circumstances, there is no chance this marriage can be preserved.
All right, we have a relatively short-term marriage of 5 years. Party been separated since December. Is your client employed, Ms. Gorski?
She is not. She's working on reviving a business she used to have. She does not currently have other employment. My child.
Okay. So, again, rather than go through each of these expenses, are there any joint debts that are being ignored?
What, just the rent and the household expenses, Judge?
Okay, but he's not living there. So at this point in time, the court's going to not order any amount, but the court's going to order the parties mediate. And then the entire resolution of this matter, go through all these details. We have some mediation dates. If you can check your calendar, this will be a Zoom mediation. Mr. Gorski, Mr. Ukpabi, how about May 20th? Do you need more time for discovery?
Yes, we do. We have not exchanged verified financials. Your Honor, the defendant is still on the lease that my client is now solely responsible for. He tried to get his name off of it. They would not remove it.
Okay, but it's alleged that he was forced out. Can he come back into the home?
He could have come back in 4 months ago when he left. He's still on the lease.
All right.
Your
The court will reserve that issue. And I'm not going to get into it. We're not going to try this case this afternoon. The court's going to order the parties mediate May 20th at 8:30 a.m. with Mr. Walker.
Judge, I'm with God for that day.
May 29th at 1:30.
May 29th?
That's fine.
1:30. Your Honor, is there any obligation on the part of my client so that we know, because we don't want to run afoul of the court rules until May 29th?
I'm sorry. And I'm sorry, can you repeat that question again?
Your Honor, I'm saying, is there any obligation from the court requires from my client before the hearing of May 29th at 1:30?
That's right. Ms. Gorski, did you understand the inquiry?
He's asking if you're ordering his client to pay any money to my client.
That's not exactly what I said. I said, is there any obligation? That's what I'm saying, not pay anything.
Well, I've not conducted a hearing. I'd like to see if the parties can work out their own differences. It sounds like the defendant is welcome to come back to the marital home if he chooses. But if he chooses not to do so, it suggests there's no chance of reconciliation. Let's move toward divorcing these two people.
So, Your Honor, do you expect any?
Obviously, let's give time for discovery, exchange the verified financial affidavits, conduct any interrogatories. Would that give you enough time for discovery? If we mediate on the 29th of May, 1:30, then with a pretrial to follow?
You know, I don't think May 29th is, because we are already in April. Discovery has to take at least 60 days.
Well, it doesn't. We don't need 60 days. Exchange of verified financial affidavits within the next 7 days. I mean, that should have been exchanged already. That's supposed to be done within 14 days of the service of the complaint. So that should be done forthwith. And then if you need follow-up interrogatories, you can do that. Ms. Gorski, do you think you need more time May 29th? I'm not going to order any payment of any expense at this point in time. I'll reserve that.
Judge, if you're ordering the parties to exchange their domestic relations verified within 7 days, I think we can get everything done by May 29th. I can send subpoenas and whatnot. That's fine.
Are your calendars, are you both available May 29th at 1:30 for mediation with Mr. Walker?
I am.
I am, Your Honor.
Okay, right. So the court will order that the parties exchange the verified financial affidavits within 7 days of today's date. And that is namely on or before May 1st, we'll say. And that's give we have short-term marriage. There's no real estate, correct?
No, there's not.
Other than the lease, there are no joint debts.
Oh, my client's vehicle has her husband's name on it.
No. That's
I'm sorry.
They told me to go get it, but they wouldn't put his name on.
We'll talk about that in mediation.
Okay.
Okay, is there joint credit card debt that needs to be addressed?
No, Your Honor.
Yeah, I put his name on all my credit cards, but I don't know how that's going. He took his name off of everything.
Okay, we can go through the debts to see whether or not they're joint debts, Mr. Gorski, what kind of expenses were incurred. But it appears that this case should be able to be settled between the parties. And you can provide the court with a copy of the lease. Is the defendant's name on the lease, Ms. Zagorski?
It is.
Okay. Well, again, there's a factual dispute of whether or not he was forced to leave. It was suggested that it's been pled that he was forced to leave the home. If that's the case, and that's relevant. If he was not, maybe it's best that the plaintiff reside peacefully by herself in that apartment. Maybe she can find a 1-bedroom or something to reduce the costs. I don't know what the term of that lease, when that expires, but perhaps that can be, you can present that to Mr. Walker on May 29th at 1:30. So the court will mail out notice that the parties engage in mediation with Mr. Walker May 29th at 1:30, and then subsequently appear before this court for a continued pretrial conference, May 29th. Hopefully the parties can reach their own agreement. So discovery can occur between now and then. And obviously these two parties need to be divorced if there's no chance of reconciliation. Probably the sooner the better.
My request for contribution then is reserved.
Yes.
Okay.
Mr. Ukpabi, any questions at this point?
Yeah, no, my question is, like I asked before, that there are no obligations in terms of financial obligations from my client until the hearing date.
Correct. The court's reserving that issue.
All right, thank you, Your Honor. Your Honor, may I ask one more thing, please?
Certainly.
Yeah, Your Honor, if it is possible, if it pleases this court, I would like Mr. Walker to recuse himself from this case because of what happened prior to appearing before you.
Well, Your Honor, I would object to that. Mr. Walker didn't do anything improper. He had his mediator hat on and he tried to resolve this between the parties.
A party has the right to ask for a referee to recuse himself. It doesn't have to be mutual agreement.
Not a referee.
Well,
Because
Mr. Walker,
when the issue of this Nigerian thing was going on, I asked Mr. Walker to intervene. He did not. I don't know what Nigerian thing means. I don't know what it means.
okay, so you want somebody else to mediate this case other than Mr. Walker?
It may be a different person, but not Mr. Walker. I would like him to recuse himself.
Ms. Patrick has appeared. I don't know if she intended to appear. Ms. Patrick, are you available to mediate on, say, May 30th at 1:30?
I can double check my calendar, Your Honor. I just want to make it, as the court is well aware of, Mr. Walker is not a referee. Mr. Walker it works for the friend of the court and is providing a service to his employer, which is the court. So I just wanted to make it clear he's not a referee. So there is no reason for him to recuse himself. However, if the party is requesting a different mediator, then as the court knows, we will accommodate that request.
Okay, that's okay. I require a new mediator. I have no confidence. I would do respect to Mr. Walker. I have no confidence in him.
Your Honor, I am available, or Ms. LaPrade is available at 1:30 on May 30th.
Actually, I'm with Ms. LaPrade on the 30th on Marciniak at 1:30. Is that not in?
That has not.
Looks like Mr. Walker sees it.
It is. Patrice, it is on there for May 30th.
Okay. Then I am available on May 30th.
Well, I won't be. I'll be with Ms. LaPrade. Are you available on the 29th?
No, that is a Wednesday. I do not mediate on Wednesdays.
We can choose a different date then.
Pardon me, sir?
I said we can choose a different date.
Date I would be available.
But June 6th.
Be available on Friday, May 31st. I can do it at 1:30.
How about June 6th at 1:30, Ms. Patrick?
June 6th at 1:30. I am available, Your Honor.
I'm with Mr. Walker on Strazula.
At 1:30, Ms. Gorski?
Yes.
Okay.
I could do it in the morning that day.
I could do it in the morning at 9 o'clock.
The court may
June
excuse
6th,
me.
Your Honor.
June 6th at 9 a.m. Ms. Patrick, you could accommodate the parties?
I could, Your Honor, yes.
Your Honor, I can update the recommendation to reflect that, as well as reserving the issue of marital contributions, if you would like me to.
Your Honor,
thank you, Mr. Walker. Mr. Ukpabi, are you available on June 6th at 9 a.m.?
June 6th.
Thursday.
Then I'm available.
I'm sorry?
He said he was available, Your Honor.
I'm available,
okay.
Your Honor.
Okay, so this will be with Miss Patrick. Miss Patrick is our Monroe County front of the court. She's head of that department, Mr. Ukpabi. So you got a very capable mediator, Miss Mary Patrice Patrick. She will mediate with the parties on June 6th at 9 a.m. Will be via Zoom. The court will provide you with Mr. Patrick's Zoom ID number, and after that mediation, you'll appear before the court. We don't have a resolution. The court would set it for trial. So the court would order that all discovery be completed before then. And the court would suggest the parties the best resolution is one in which they both participate and ultimately reach their own agreement on, rather than this court deciding the matters. So please keep an open mind, June 6th, 9 a.m. Is there anything further? Thank you, Ms. Patrick, for zooming in and clarifying things and your willingness to assist.
You're welcome, Your Honor.
Thank you, Your Honor.
Anything further? Ms.
No.
Gorski, Mr. Ukpabi? Okay.
Yeah, no, nothing, Your Honor. Your Honor, we expect the scheduling from the court.
Okay, so but please get off the forward the exchange the verified financial documents by by May 1st, and complete discovery. We'll serve one on June 6th after the 9 a.m. mediation.
Sounds good. Thank you.
Okay, thank you all. For the record, this matter is before the court, presumably for entry of a order regarding custody and parenting time. And this hearing is being conducted via Zoom. Present as Attorney Kimberly Kuhn, representing the plaintiff, the father. Charles Redding. Mr. Redding is present. In addition, Attorney Alex Goldman is present, representing defendant mother Chloe Lewis, and Ms. Lewis is present. This court did enter an ex parte order on February 26, 2024, which prohibited mother from removing the children from the state of Michigan and requiring her to return the children to the plaintiff father. The matter was set for hearing on March 6th, at which time the parties appeared. They confirmed paternity of the minor child Miles, and the defendant, I believe, wished to consult an attorney, and she has since brought on board Mr. Goldman. Parties have conferred with Ms. Patrick this afternoon. One moment, I'll share with you her recommendation. It is simply noted that the parties are currently residing together. So, due to the fact that the parties are living together, no need for any type of custody or parenting time order. Is that correct?
I disagree, Your Honor. The parties are not getting along. There have been threats made by Miss Lewis to leave the home. There have been threats made to get a plane ticket and go to Arizona. I don't want to be in the same position.
That is not true.
Where I am running back into court and asking for orders to prohibit a party from taking the children out of state. My client also said that the parties are not getting along, that there may be an eviction proceeding. So Ms. Lewis might be finding alternate housing because the parties aren't getting along. So yes, they're living in the same home. No, it's not going well. It behooves me. I can't comprehend why the parties won't agree to joint legal custody. My client right now doesn't have any rights to weigh in on medical. The kids are young, they don't go to school yet, but before we know it, that's going to be an issue. So really, if nothing's done, we're going to be back here in a month because things aren't going well. So yes, they're living together. No, it's not going well. There have been threats to go. So why wouldn't we agree to joint legal custody, reserve parenting time until they've moved out and they're living separate and apart, and also have the standard language that the children are to remain in Michigan unless by further order of court. So I would really like to put the protections in place that aren't in place without some type of custody order. And Your Honor, there's no reason why these parties can't share joint legal custody of their two children. So I would argue that the situation at hand warrants some type of custody determination when it comes to decision-making regarding the minor children and also keeping the children in Michigan. This was a case where the police had to get involved, and it was not a good situation to get the kids. Miss Lewis was hours away from getting on a plane and going to Arizona. So I just don't want to see the same situation happen as it has. I have a case right now where there's a felony warrant out now because one parent took off with the children because there were no orders. So I am asking the court to award the parties joint legal, reserve parenting time, and keep in the order that the children can't be removed from the state of Michigan without the court's permission.
Thank you, Ms. Kuhn. Obviously, this court has jurisdiction over these children right now, and certainly the court would continue the prior order that neither party shall remove. Obviously, the prior order was that the mother shall not remove the children from the state of Michigan, but the court would order that be both ways. Neither party shall remove the children from the state of Michigan. Any objection to that, Mr. Goldman? This court reiterating that neither party shall remove the children from the state of Michigan?
I do, Your Honor, just because I think that there doesn't need to be any custody order issued at this moment. The parties are currently residing together. I think it's abnormal to have a custody order in that situation. I don't know what's going to happen in a month or two. I know that Miss Lewis has no plans to leave. It's news to me that things are not going well. I think the parties are actively working on reconciliation. And if something needs to be filed in a month or two, so be it. But I think it's premature at this stage.
There's an action pending before this court. This court has jurisdiction over the children, so the court will order that neither party shall remove the children from the state of Michigan. And in case they separate this weekend, they should the court's going to order that they share joint legal custody. They share equally in major decisions concerning the welfare of the child. For example, if his child is taken to the emergency room this weekend, the other parent should have some say in terms of whether or not that emergency medical treatment is administered. And I don't see that's in the best interest of the children. So if you want, we can schedule a review date in 30 days if we need to address parenting time. But yes, parenting time is clearly premature, but the court will order that the parties have joint legal custody and that neither party shall remove the children from the state of Michigan. And at this point, do you want a review date in 6 weeks, Mr. Goldman, Ms. Kuhn? Or do you want to wait for for either party can really notice it? But in the interim, neither party shall remove the children from the state of Michigan, and they shall share equally any major decision concerning the welfare of the children. They're 2 and 1 right now, so the only issue is medical treatment. And obviously, if the children are with dad, dad should certainly make sure mom's aware that he's taking the children to the emergency room, and vice versa. So that's the intent of the court. I believe that to be best serves the children. The only question again: do you want a review date in 6 weeks, or do you want to simply notice it up if things change?
I can notice it up if things change, Your Honor. I don't know how long an eviction proceeding takes, so I can notice it.
Let's try to be optimistic. Maybe the parties can sever or maintain and preserve the relationship for the benefit of the children. Work things out between them. So at this point in time, the court will, we can note, Ms. Patrick, the parties are residing together, but the court will order joint legal. Neither party shall remove their children from the state of Michigan. Mr. Roman, anything further from your standpoint, your client's standpoint?
No, Your Honor.
All right. Ms. Patrick, you just add a couple of those provisions to the recommendation.
I did, Your Honor. I will upload that into your queue.
Right. All right. Anything further, Ms. Kuhn?
No, Your Honor. Thank you.
All right. So, the court would hope that the parties, for the benefit of these 2 children, 2 and 1 year old, can co-parent.
Hey, Ms. Kuhn?
I'll call you, Charles.
Okay.
We're hearing third parties. I'm not sure where we're picking up these third parties from. I'm hearing noises in the background.
I'm sorry, that's my children.
Go
Okay.
ahead and mute yourself, Charles, if you can.
All right. That will conclude, sir. You can all zoom out.
Thank you, Your Honor.
Thank you, Your Honor.